A woman and a man appear before us, both white, both dressed in the formal black robes and white bavettes worn by lawyers in the European court. The lawyer on the right holds papers in her right hand and a red pen between her fingers. Looking straight ahead, her gaze meets ours. It's serious, imploring. Yet, whatever gravity her gaze holds is modified by the somewhat bemused expression of the second lawyer who sits behind her. We assume that he is contemplating the arguments being made by his counterpart. Through his eyeglasses, we see that, like her, his eyes are also trained on us, the imagined judge or jury in whose hands the power of decision rests. The two lawyers stand and sit respectively with the large blackboard as their backdrop. 4 slate slabs, bearing the marks of multiple inscriptions and erasures. We see here a decoupling of the lawyers from the proper context of a courtroom. Yet, if this is not a courtroom, then where do they argue? In what context would such formality or such theatrics be necessary? At the level of the image, the subject and the substance of their argument remains outside our grasp. At a more fundamental level, we cannot access what or who they're arguing for. Whose interests do they represent? On whose behalf do they presume to speak? How do these photographically displaced and anonymous individuals register within this imagined courtroom? Are they among the mass of those who are invisible in the eyes of the law, but nonetheless subject to it? Of any of this, we cannot be certain, just as we cannot assess by way of the image the prevailing conditions in which the case originated in the first place. Indeed, this ambiguity surrounding the individuals being represented attests to these conditions, which, like the erasures on the blackboard, at once reflect the mark of a social inscription and an erasure from the surface of political visibility. Taken in December 2007 at École des Beaux-Arts in Paris, this image documents a project by French artists Patrick Bernier and Olive Martin, X and Y versus France, the case of a legal precedent. In this work, the artists collaborated with 2 lawyers, one specializing in immigration and the other intellectual property, to develop a legal argument whereby undocumented immigrants, posited as co-authors and guardians of immaterial, site-specific artworks, can avoid deportation through the application of laws relating to intellectual property. The argument is delivered by 2 lawyers who perform the closing argument of a fictional deportation hearing before an audience, to whom briefs containing factual legal precedents are given in advance. Although each performance of X and Y versus France varies slightly depending on the venue and its audience, in substance, the argument remains the same and can be summarized as follows. A European artist, Y, is co-author with an undocumented immigrant, X, of a site-specific dematerialized artwork, of which X is the sole guardian. The integrity of the artwork depends both on its location, France, and on X's ongoing interpretation of it. As the carrier of a work of the mind bearing the mark of the author's personality, X is entrusted with this work for life and another 75 years after death, at which time the work can enter the public domain. To deport X would thus destroy the work, thereby violating the right of the European artist, Y, to prevent unauthorized alteration and dissemination of their intellectual property. My thesis project analyzes contemporary artworks that take the form of laws and legal precedents. And while these works can be situated alongside broader strategies within activist communities and left-leaning political projects that aim to ensure equality through law and policy making, strictly legalistic practices have the effect of reducing concepts of politics to the ability to negotiate with and make laws. By focusing specifically on the project by Patrick Bernier and Olive Martin, I hope to address this reduction of the political, as well as the assumption that increased rights and laws and their attendant forms of visibility within the public sphere are necessarily capacitating or protective. Complicating established debates surrounding immigration and the production of nationalisms, X and Y versus France questions the relationships between life, law, artistic practice, and political efficacy. For today, my presentation will emphasize the work's implications with respect to concepts of visibility. The 2007 performance of X and Y versus France came directly on the heels of a series of riots that took place in the Parisian suburbs during November of that year. This recalled a 3-week period of unrest 2 years prior, when the death of 2 French youths of African descent at the hands of police sparked violence in the suburbs of Paris and 274 towns throughout France. By 2005, France's immigration policies had become among the most restrictive in Europe, and tensions surrounding these policies were exacerbated by comments made by then Interior Minister and now President Nicolas Sarkozy, who called for a, quote, war without mercy on suburban scum, directly linking violence to immigration and the country's rising Muslim population. And while a number of the rioters were first and second generation immigrants from North African and Islamic countries, the issues surrounding the riots were far more complex than a culture clash. Immigrants from France's former colonies in Africa and the Americas are among the most culturally, economically, and politically excluded groups in Europe and are subject to widespread racial discrimination and xenophobia. Commonly referred to as the visible minority, France's immigrant population is not simply barred from legitimating forms of visibility within the public sphere, but is forced into view as a threat. Sarkozy's statement, France, love her or leave her, attests to the country's integrationist policies in which ethnic and cultural differences are subordinated to cultivating a homogeneous national identity of mythical purity and authenticity. The 2004 ban on Islamic headscarves in public institutions and schools is perhaps the most controversial example of such policies. However, the events spanning 2005 through 7 offered the government an opportunity to once again tighten immigration policy and further nationalist discourses, including in 2007, the establishment of deportation target numbers and the founding of a Ministry of Immigration and National Identity. X and Y versus France operates within this movement, pointing to the wrong instituted by the law itself as a naturalized and legitimating order whereby bodies appear either as valid, speaking political subjects, or invalid, illegal, and speechless. In the words of the artists, it is an open sourcing of French national identity. And it is precisely this expanding and narrowing, inclusion and exclusion of what is visible, sayable, and sensible, and by whom, that the philosopher Jacques Rancière has described as the politics of aesthetics. For Rancière, this distribution of the sensible is the way that forms of sense perception in which an individual may be included or excluded, recognized or unrecognized, are distributed among a population. Aesthetics simultaneously reveals the existence of a world held in common by the community and the delimitation of roles, spaces, and times within the community itself. As both a means of inscription within spheres of visibility and a way of acquiring legitimacy within those spheres, aesthetics conditions who can do and say what, as well as when and where. In other words, it is a way of gaining recognition as members who have a say, a stake, and a share in the community. When viewed through this lens, the link between politics and participation in electoral, governmental, or legal processes is broken. Rather, the notion of politics forwarded here is a politics of the subject in constant negotiation with received modes of visibility. In her discussion on the legal status of foreigners throughout history, Julia Kristeva suggests that the very act of founding rights has its corollary in practices of exclusion. She writes, "In order to found the rights that are specific to the men of a civilization or nation, even the most reasonable and the most consciously democratic, one has to withdraw such rights from those that are not citizens, that is, other men. Between the man and the citizen, there is a scar, the foreigner. Immigrants and foreigners are thus reduced to a scar on the body politic, embodying the memory of a wound inflicted by their own exclusion. While human rights are considered fundamental, they nonetheless demand articulation at the level of the state, which reserves the power either to recognize or withhold them. Undermining governmental claims to distribute justice or capacitate individuals equally, the nexus between the rights of the citizen and the rights of the human is broken from the moment of its inception. This recalls what Giorgio Agamben has described as the state of exception, understood as the temporary suspension of the juridical order, the paradoxical invocation of the law in order to suspend its protections, a state of being that is simultaneously in and outside of the law. It is in this state, Agamben writes, that the link between life and law is held at maximum tension. In contradistinction to the liberal humanist concept of a transcultural, transhistorical natural law preceding the development of a civil society or the emergence of the state, he describes law as having no fundamental relation to life. The same can be said for human rights. Indeed, for him, the act of showing law in its non-relation to life and life in its non-relation to law is to open a space for human life apart from the governmental forces that seek to manage and economize it. As individuals existing outside the realm of legal protections, but to whom the law nevertheless applies, immigrants without documentation are at the center of this crisis of state power, economics, and law. Unrepresentable within traditional frameworks of citizenship, nationality, and human rights, immigrants without documentation throw the very concepts of the state and legal sovereignty into question. More than a reflection of the state's capacity to produce representations of its population, this suggests that without citizenship, human rights become unthinkable. The aesthetic content of X and Y versus France, understood as the delimitation of spaces, roles, and times, points to a different way of thinking equality. In its capacity to make multiple subject positions visible, sensible, and sayable, as members who have a part in the sharing of what's common, the project by Bernier and Martin engages the law's claims to legitimacy. As an articulation of subjectivities in transition between forms of visibility and invisibility, citizen and non-citizen, author and artwork. This work not only points to the limit of law to address the promise and the problem of equality at a fundamental level, but also the ways in which the law itself is constructed to perpetuate inequality. By asserting the equality of immigrants without documentation, Bernier and Martin point, on the one hand, to the arbitrariness of the social order, and to the non-relationship of law to the fact of equality on the other. This is the tension that is created between X and Y, between who is recognized as legitimate or illegitimate, and the very conditions of that recognition. The politics of X and Y versus France can thus be considered apart from any claims to efficacy or its overtly political content. Its politics are not in the application of the precedent that it proposes, or how many immigrants that it can serve. Rather, its politics come from the assertion of equality and the irrelation of law to life that it enacts and makes visible. Thank you.